Real estate?
Good afternoon, Your Honor. James Bernard, for Appellate. I have 5 minutes for the initial argument, 2 minutes for the public.
Yes.
And Roger Saturn, for our respondent, we give the second.
Thank you. People v. Wilfredo Richardson, submitted. Zelig versus New York City Department of Housing, 5 and 4. Barbado versus Giason, 5 minutes for the appellant, submitted as to respondent. 20 West Properties versus Banks, submitted. Jacque V, submitted. Mejia versus Unique Developers, submitted. People v. Christopher Della Rosario, submitted. Way versus NASDAQ, 10 and 10. Brightman versus Sim, 5 and 5. Fonabayo versus Beacon Broadway, 7, 7, 7, and 5. Petre versus Lucia, submitted. Acna, versus 207-217 West 110th Street, submitted. Global Liberty versus Avantgarde Supply, submitted. So, attorneys, I just want to remind you that we have your briefs. We've read your briefs. Also, please do not speak over the justices. First case for argument is People versus Henry Wachtel.
Good afternoon. The core of this case was epilepsy. All parties agreed that Henry Wachtel was not guilty by reason of insanity because the killing occurred during the post-ictal stage of a grand mal epileptic seizure. All parties agreed that the killing was not intentional or knowing, and in fact that Henry Wachtel to this day has no memory of anything that happened, because during an epileptic seizure, the brain does not make memories. Experts for both sides said that the key to making sure Henry Wachtel is not dangerous under the statute is to control his epilepsy.
Counselor, don't the various experts also agree that a strict compliance with the medication regimen is critical in order for this defendant to remain stable?
Yes, they do. And in fact, Henry Wachtel was switched to a medicine called Depakote in 2013.
But counsel, didn't the defendant, wasn't he found in non-compliance with his medication even while he was at Rikers?
No, that's not correct. Henry Wachtel has not missed a single dose of Depakote. When the prosecution's experts said he was not compliant, what they meant was that because Henry Wachtel has problems managing sleep and with sleep deprivation, he frequently took his medication at a time other than the time scheduled, but always on the right day. He never missed a dose.
But wasn't he also taking other non-prescribed medication, heroin, or I believe it was heroin?
When he was at Rikers Island, which is probably the world's largest indoor drug market, Henry Wachtel was using illegal substances.
Wasn't he also using heroin at Kirby? Wasn't heroin smuggled into Kirby for him?
Yes. What happened was,
A secure
while he was
psychiatric facility?
I'm sorry?
Kirby being a secure psychiatric facility.
It supposedly is, yes. However, during the time that he was at Rikers Island, his second stay at Rikers Island, when he was still using drugs, but had been switched to Depakote, despite the fact that he was using illegal drugs then, he had 0 seizures, none.
Well, counsel, the issue becomes, I see your expert states that he will no longer be violent. And I'm really curious as to how someone could make that determination based upon his history, not only the fact that he killed his mother and the circumstances under which he killed his mother.
Well, the circumstances under which he killed his mother was in the post-ictal stage of an epileptic seizure, meaning that it was not intentional, it was not knowing.
And it was 6 years ago. It was in 2012 that he actually killed his mother. Is that correct?
That's correct. And since then, one of the factors that the experts based their opinion on was that he has not engaged in a single act of violence, despite being provoked, for that entire time. He has not threatened anybody with violence for that entire time. And everyone agrees to that. This is one of those situations where proving a negative, proving that someone will not be violent, can be done based upon projection, and it can be done based upon what his behavior has been. And for more than 7 years, Henry Wachtel has not done anything violent. Even at times when he was attacked, when he was at Rikers Island, attacked by other inmates, or provoked by guards, he did not fight back. He did absolutely nothing violent. Now, the prosecution offered a fairly complex formula in which, if he used illegal drugs and stopped taking Depakote and had a seizure, he might hurt somebody. The fact of the matter is, as Dr. Bazil, who is the chief of epilepsy studies at Columbia Presbyterian, a board-certified neurologist who teaches at Columbia, trains neurologists all over the world, what he said was that the likelihood of Henry Wachtel ever having a seizure again is vanishingly small, and that's a quote. And he said that because the Depakote is obviously working, and because...
How long has he been on Depakote?
Pardon me?
How long has he been on the Depakote?
He's been on Depakote since 2013. From the day he was put on Depakote until today, he has not had another seizure. And he has done absolutely nothing violent. The problem with the lower court's decision was that the prosecution's only expert on epilepsy, Sarah Schaefer, repeatedly admitted on cross-examination, and I'm using her words, that her opinions were guesswork, speculation, that she had no scientific or factual basis for her
Counsel,
opinion.
would you address, please, the defendant's mental illness and the role that it plays here?
Well, he has a couple of mental illnesses. He has ADHD. He has various other illnesses, but none of them have caused him to be violent, and that's the question here.
So you're saying that he doesn't have a dangerous mental disorder?
We are saying that he is definitely mentally ill. He has a mental illness. We are not asking that he be released. I mean, that is not part of our argument at all. We have said all along, he should have been put on track 2 in a civil facility.
Thank you, counsel. You can continue on your rebuttal.
Thank you.
Good afternoon, Your Honors. Noreen Stackhouse for the people. There is ample support in the record for the court's decision that defendant is dangerous. First, it was uncontroverted at the hearing that defendant's seizure was caused by a combination of sleep deprivation, stress, noncompliance with his epilepsy medication, and substance abuse.
So your adversary states that the defendant has not had any dangerous episodes. He has not shown any violence towards anyone, even when he was actually provoked at Rikers. And so that would show that he does not that he's not still suffering from a dangerous mental disorder.
Well, that's not exactly true. He did threaten people at Bellevue. He's threatened other patients at Kirby. He hasn't engaged in physical fights except for one fight at Bellevue, but he's been in a secure facility or in prison for most of that time. Those facilities are generally aimed at preventing violence from occurring, and even at Kirby, on I think 3 different occasions, he had to be given sedatives to calm him down when he became so enraged that they were afraid they were going to have to restrain him.
But he's not on any medication that would prevent him from being violent. Is that correct?
I believe he's on antidepressants, but I think the main issue, though, is with his epilepsy and how the mental illnesses are intertwined with his lack of insight into the role that he played in his mother's death. I mean, that's the main issue, is that he blames it on his old epilepsy medication, Keppra, even though Keppra has never been shown to cause this level of violence. I mean, this kind of episode is very rare in general. He basically says it was a freak accident and that he wasn't conscious while it was happening, which was true, but he doesn't take responsibility for the fact that it was his substance abuse, his sleep deprivation, his stress, all of that played a role into causing the seizure and the
There
level
was
of
a history
violence
before this.
afterwards.
Counsel,
There was a
can
history
someone,
before the murder, wasn't there?
Sorry, Your Honor, I can't hear you.
There was a history of threats and various incidents between the mother and son before the son killed his mother.
They had, by all accounts, a loving but very volatile relationship, and he had gotten into shoving matches with both his mother and his father. He had threatened to kill her in the past, leading his therapist to tell her to call 911 the next time he did that. That was all predating the seizure.
Counsel, Justice Shulman has a question.
Sure.
yes, one can suffer from a dangerous mental illness where the patient poses a danger to himself, i.e. suicidal ideation, which he has experienced during his hospitalization, correct?
Yes, and he is
in a sense, that's violence to oneself.
Yes, and we also submit that he is a danger to himself for two reasons. One, the risk of overdose. He is so highly addicted to drugs that he managed to sneak heroin into a secure facility, which every doctor that has worked there says that's extremely rare. And then there's also the risk of suicide. He's expressed suicide ideation at every facility that he's been at. And to the extent that counsel argues that he hasn't expressed it more, we know from his records at Arbor Place that he is reluctant to share those kinds of things with his counselors because he knew those notes were going to get back to the court. So to the extent that there's not more information in there, he has, most recently at Kirby, when he was caught with heroin, was placed on a 24-hour observation because of his suicidal ideation. And what defendant fails to realize is that all of these issues are intertwined. It's not just the epilepsy, it's not just the substance abuse, it's the mental illnesses. They all combine to make it a very real threat that if he stops taking his medication, if he starts using drugs again, which a lot of the doctors say is almost a certainty at a Track 2 facility, apparently those places are like sieves with respect to drugs, then something like this could happen again, and he could very well injure someone again. If there are no further questions, I'll ask the court to affirm the lower court's decision. Thank you.
Yes, Counsel, you have 1 minute.
Thank you. In fact, Mr. Wachtel, whether at Kirby or anywhere else, has not made threats to anyone. He has done a lot of name calling. He has been obnoxious at times, but he has not threatened anyone, and he has not done anything to back up any of the name calling even. It is true that Mr. Wachtel has a substance abuse problem. Everybody knows that. But substance abuse in itself does not cause epileptic seizures. It did not cause the epileptic seizures here. And in fact, we don't, as the prosecution's own witness, Dr. Hicks said, a Track 1 facility is for psychotics, for schizophrenics, paranoid schizophrenics, people seriously bipolar, people who have a loose connection to reality. Henry Wachtel is not any of those things. We don't treat drug addicts in Track 1 secure facilities. Everyone agrees that the treatment for a drug addiction is much better.
Well, we're talking about a little bit more than a drug addiction, I think.
But he had serious drug addiction. But
But
even
the drug
during
addiction did not lead him to killing his mother.
Pardon me?
The drug addiction was not what caused him to kill his mother.
No, it was not. He was in an it was in an epileptic seizure. And what the experts have said, certainly what Dr. Bazil said is that he is not going to have another epileptic seizure. He's on Depakote that could easily be monitored in a Track 2 facility. Everyone agrees to that. And since he has not either had a seizure or done anything violent or threatened anything violent for 7 years, we're finally faced with the question of what more does he have to do to show that he is not dangerous?
Thank you, counsel. We appreciate your arguments. Thank you both.
Thank you.
The next case is Lai versus Charles Innes Housing. Yes, whenever you're ready.
Good afternoon, Your Honors. May it please the Court. I'm Matthew Mann from Babchick and Young, representing defendants appellants Charles Innes Housing Development Fund Corporation and Wynn Residential NY LLC. In granting plaintiff's cross motion for summary judgment as to his Labor Law 241-6 claim, the trial court erred in failing to recognize that there are questions of fact regarding the violation of the industrial code upon which that's based. It is not at all uncontroverted that the blade protection guard malfunctioned at the time of the incident. The plaintiff...
So would that mean that when he was given the guard, given the saw from the building superintendent at the direction of his employer, hey, take this one, go up on the roof and do your work, he was in possession at that moment of a saw that was not sound and operable under the applicable section of the industrial regulation, as you acknowledge?
That's exactly where the tribal issues of fact lie. The plaintiff testified that there was a mechanical issue that the saw's guard did not automatically spring back into place when the trigger was not depressed. And he testified that the superintendent warned his employer of that. Meanwhile, the superintendent testified that the last time he had used the saw, there was no such problem. He used it 6 to 8 months previous and had no problem in terms of the function of the guard. It was not used again. He denied ever advising the employer of any safety issues with the guard. And when the saw was retrieved, the superintendent testified that the guard was still covering the blade. The other issue, in terms of questions of fact, plaintiff testified that there was a gradual buildup of tar from cutting the surface of the roof, and that buildup stuck the safety guard up inside of the saw such that he could not even manually put it into place anymore as he had been able to do before. He testified that, and direct quote, "You are not able to move it with your hand even if you use a hammer." Meanwhile, the superintendent testified that, again, not only was the blade guard covering the blade at the time that he retrieved it from the scene of the accident immediately thereafter, it was stored, the saw was not used, until the time that it was tested by the
I have a different,
expert engineer who...
counsel, I have a different question.
Yes.
So, Mr. Weinstein, the defendant's engineer,
Yes, Your Honor.
testified that roofing materials such as tar will adhere to the blade of a saw and collect inside the interior of a lower guard, ultimately impeding the guard from going back to its normal safety position. So given the fact that this was a tar roof, period, how could this saw have been the proper tool for dismantling the roof?
In fact,
Your expert says, in fact, that this was the wrong saw, didn't he?
I don't know that he gave that opinion, but he did opine that there was no tar in place when he actually inspected the saw.
But it's a tar roof.
It was a tar roof, but
And so then the question posed by my colleague was whether or not this was a proper tool, given the fact that it was a tar roof.
I don't know that he opined either way on that matter.
Sorry, it's really hard to hear because we're all speaking.
I apologize. I apologize.
Just talk louder if you would.
I'm sorry. I apologize for that.
That's okay.
I don't know that he opined either way as to the propriety of the saw for the task at hand.
No, I'm asking the question.
You're asking me that.
How could this be the proper tool if your own person said, by definition, tar is going to adhere to the saw and make it inoperable? We know that this was a tar roof. Therefore,
He said that it could do that, and the reason that he said...
Sorry, he said that in,
He said that it could do that, the TAR could do that, but that was in connection with our initial summary judgment motion based upon superseding intervening cause. And in connection with that, we took the plaintiff's testimony as true, meaning that we accepted as true that the tar was impeding the safety guard. However, the inspection of the expert proved the opposite. And
Thank you, Counselor.
thank you.
May it please the court, Ian Ash for the respondent in this case. It's our position, obviously, from the brief that Judge Suarez's opinion granting our cross motion was proper.
So are there any issues of fact or questions as to whether or not the tool was in fact, when the tool was given to your client, that it was in fact defective, that he was told that it was defective, and that he used it at the direction of his supervisor?
The only relevant testimony was, the only undisputed testimony here is on the day of the accident when he was giving it, the blade guard was not retracting back from the very onset when he was given it. When they attempted to kind of engage in a Plan B argument in response to our cross motion and say, well, now there's proof that it was not defective at all. First of all, my opinion is that the expert did not initially reveal those findings because they kind of contradicted the idea that it was unchanged in the 3 years and 3 months since the accident. He didn't see any evidence of tar sticking, anything on the, according to his inspection when he revealed the results. But you have, number one, plaintiff's testimony. You have an accident that, according to every witness could not have happened if the blade guard was retracting back. Their expert in the second expert affidavit offers no explanation whatsoever as to how this saw, the unguarded saw, could have cut his leg if it was retracting back. It's based on an examination 3 years and 3 months after the accident involving a device that is very easy to alter, repair, or change. You could or clean if there was tar on it. And then they also try to rely on the testimony of their employee. And I pointed out that the testimony at the very best was equivocal, that when I first asked him, after the accident, when you looked at the blade, at that saw, did the blade guard appear to have adjusted back? He said no. I mean, I quote that directly. He then said he made no observation about the blade guard. Then he said when he picked it up, it appeared as if the blade guard had adjusted back, but he admitted he never used it again, never tested it, never tried to adjust it. So here you have an accident that just factually could not have happened unless the blade guard did not retract back, unless it's like some sort of magical occurrence. And they're essentially offering speculation that the accident didn't happen the way the plaintiff said. So really the only testimony you have, the only real concrete testimony, tangible testimony you have here is the plaintiff's testimony that it wasn't retracting back.
Well, the supervisor, Sosa, he did state that after the accident, he saw the tool lying next to your client and it looked fine.
Well, he testified initially, his initial testimony was, did it appear as if the blade guard had adjusted back into place? And this is on page 372 of the record. No. Then he was asked, did you make any observations about the blade guard or whether it adjusted back? And he said, initially no, 372, 373, 376. And then he ultimately says that, on page 376, when he picked it up, it looked like the blade guard adjusted back. But let's accept that for the sake of argument. It doesn't do anything to disprove that the accident happened exactly as the plaintiff said. And they've offered no alternative explanation as to how it could have cut into his right knee if the blade guard was working properly. I mean, this isn't a case where somebody's finger is sucked in when they're holding a table saw, which sometimes happens. This is a case where there's no other way this could have happened. I mean, their expert said it would bounce back immediately. Their witness, Mr. Sosa, I asked him point blank, if the blade guard was adjusting properly, could this accident have happened? He said no. I mean, if the court has any other questions. Thank you very much.
Thank you.
One moment.
You didn't ask for any rebuttal.
Okay.
Thank you.
Thank you very much.
Next case is Stafford versus A&E Real Estate. Whenever you're ready.
Thank you, Your Honor. May it please the court. This purported class action concerns the rent overcharge claims of 68 named plaintiffs and is before this court on defendant's appeal of a decision below which applied the statute of limitations regime contained in the HSTPA and which denied defendant's motion to dismiss 62 of those claims as untimely. There's no dispute between the parties that the decision below should be reversed because the decision below applied the HSTPA statute of limitations regime, which now the New York Court of Appeals has made clear in Regina should not have been applied. And therefore, the only issue before this court is whether or not to simply reverse and remand for a determination under the pre-HSTPA law, or whether or not this court can apply that pre-HSTPA law to determine whether or not the claims were timely. Now, both sides have submitted briefing on that issue, and I think both sides would agree that it's appropriate for this court to decide that issue, because at the end of the day, these are the kinds of questions that are decided on the record below. It's a motion to dismiss.
And if we decide that type of issue, how do you propose we decide?
The 62 of the 68 claims, Your Honor, are untimely. There is really no dispute between the parties that with respect to those 62 claims, 62 plaintiffs, those claims took place outside of the 4-year period of time. The dispute between the parties is whether or not an exception applies to that issue or to that timeliness. The lack of
Sir, wouldn't discovery into the fraud issue, if the complaining tenants are able to establish that the, by way of example, the IAI increases were fictitious, which boosted up the legal regulated rents to the, quote, deregulated rents before the 4-year period, arguendo. That would arguably establish a fraudulent scheme to deregulate, which would permit going beyond the 4-year look-back period. So against that construct, and this was a pre-answer motion, without any of the discovery, it was just merely on the pleadings. Would you not agree in principle, I know what your position is on your brief, but would you not agree on principle that assuming discovery they were to meet their burden in establishing fraud, then the action would eventually be deemed timely? No?
I understand the question. Yes, Your Honor. In principle, that's correct. But for 2 reasons, I would submit it's not an appropriate response here. Number one, as the New York Court of Appeals did make clear in Regina, the statute of limitations exists to encourage repose. And these cases are frequently decided on motions to dismiss without discovery in a pre-answer motion such as the one below. And that's important because ultimately the law is intended to encourage parties to have comfort that after this 4-year period of time...
Okay, but counsel, this is Judge Scarpula. In this circumstance, the allegations of the complaint are what they are, and are you arguing that they don't make out a colorable fraud claim? Because really that's...
Yes, Your Honor.
Yes, all of what you're saying is true, but we want to focus on this case, not about general stuff about real estate law and statutes of repose. So in this case, why don't you think this is a sufficient allegations of systematic fraud?
The reason is, Your Honor, is because the allegations in this complaint don't rise to the level of the kind of allegations that the courts have recognized satisfy the fraud exception. Grimm, for example, is a case in which there was evidence and pleading of collusion between the plaintiffs and the defendants. In fact, the landlord and the tenants actively avoiding the regulatory scheme to try and deregulate units. Let's just take an example.
No, I just want you to tell me about this complaint. What is it missing that you think has to be there?
Paragraph 15 is a great example, Your Honor. There are some 60 paragraphs in this complaint that are all almost identical, and here's what they read. Plaintiff Jeffrey Nat lives in apartment 4F.
Counsel, let me make it easier for you. So here you have a putative class divided into 6 groups, and the allegations in each of the 6 groups are very different. Why would discovery impede the court's ability to decide whether this is properly brought as a class action suit, for example? And why would this not constitute a colorable claim as to fraud? Take a look. One set of people, they're talking about rent increases that they believe are unlawful within 4 years of the complaint's filing. 16 tenants are talking about improper luxury deregulation. 8 people are talking about large gaps in the registration history. Other people say, 3 other people talk about contemporaneous IAIs that they say did not exist. Then you have the 5th group. They say that there's impermissible preferential rents that followed rentee control. And then the last one, you have an assortment of 32 people with different allegations. Under this set of circumstances, why is this properly brought as a motion to dismiss? Why not wait until discovery?
Because, Your Honor, those 6 groups are, with due respect, an artificial characterization or amalgamation, if you will, of the plaintiffs that don't fit what is the sole exception to the rule, which is whether or not there has been an allegation of a scheme intended to deregulate units.
But you're talking about buildings that are commonly held, buildings that are commonly managed. There you have 22 buildings, 55 apartments, 68 people. So why not wait until discovery?
Because, Your Honor, these kinds of motions are made at the pleading stage all of the time. And what we need to focus on is the paragraphs like the
You mean your
one...
motion to dismiss is commonly made at the pleading stage?
Absolutely, Your Honor. These kinds of issues that go to statute of limitations are made all the time at the pleading stage. And this is why, in answer to the Justice's question earlier, I was focused not on these artificial 6 categories that have been created, but what are the allegations in the complaint? And the complaint does not contain the kind of detail that the courts have held is appropriate in order to avoid the 4-year statute of limitations. I would submit, Your Honor...
I gave you additional time because we did run a little over, but you reply on rebuttal. Thank you.
Thank you. I'll hold.
So, counsel, if you could just please address the allegations and the sufficiency of the allegations, I'd appreciate it.
Sure. This is sharply identical, Justice Weber. You would be very familiar because we talked about this in Weber and we talked about this in Quinn. These are the exact same type of allegations in those cases. Preferential rents following a decontrol, registration gaps, failure to demonstrate apartment deregulations, contemporaneous IAI issues. The difficulty for any tenant filing a rent overcharge case is that the evidence, the evidentiary material, is in the landlord's hand. What they're trying to do
But you know, counsel, it's interesting because you're kind of agreeing with your adversary because to some extent you are admitting that these are boilerplate allegations, and so they do in fact lack specificity because this is what occurs, or this is what you allege in all of these cases.
Well, let's be careful, because remember there are cases, or there are claims, for instance, the contemporaneous IAI, I know that the tenants didn't consent to that, because they've said, we didn't consent to that. Same with preferential rent off a decontrol. Very easy to see, right? You look at the rent history, it says apartment decontrol, preferential rent, legal regulated rent. The only issue is with respect to these IAIs. And in an IAI case, when there is a deregulation, the burden is entirely on the landlord. A tenant is allowed to go in and say, my apartment was deregulated, where's your proof? And the landlord is obligated to provide that. The only part where it's somewhat conclusory is with these tenants whose apartments were never deregulated. But even there, and this is the language from Maddox, the proof for these other tenants is going to impact that proof. And if we've identified an indicia of fraud, systemic, we should be able to take discovery and see what proof the defendants have.
And then I guess the corollary to that is on the motion for class certification, if some of these plaintiffs don't fall in that group, then they fall out of the class.
Right, I wouldn't even bring there's a potential that I may not even bring the claim on behalf of those tenants, or I may we may utilize CPLR 906. Trying to dismiss this case prior to class certification, prior to discovery, would just encourage every landlord, I know you wanted to talk about specifics, but we do look at this universally, would encourage every landlord, anytime a tenant files a deregulation claim, to say, hey.
No, I don't want, no. What is it in this case? Tell me what the specific allegations of fraud are in this case.
You got it. Failures to register coupled with rent spikes. That's Butterworth. Preferential rent following a decontrol. We know that that's impermissible. Failures to demonstrate.
Wait, I'm confused. Forgive me, I don't want to belabor that last point. It may very well be that the 3 tenants that are subject to that preferential rent scenario you described will not be part of the class. But you understand that under the rent stabilization law, if there's been a vacancy decontrol, a landlord has the ability to negotiate a first rent with that first tenant taking occupancy, correct?
Right, that's the problem.
Just bear with me for a moment.
Yeah.
And again, I don't have the exact code provision in place for the timeline because it's not, I didn't memorize the complaint, so forgive me. The point is they could have moved in at a time when the rent stabilization law and code allowed for a preferential rent, where he negotiated a higher rent and preserved if he served the initial registration statement and gave them notice that they could arguably challenge that first rent as a fair market rent appeal. I know you're following where I'm going. So putting all that aside, the real question I have in my head, and I tend to agree with you, is that, but for all that to flesh out, you need discovery. You can't just rest on a pleading, correct?
Right. Right now, at this initial threshold stage, all we have is a rent statement.
And you would recognize that in one of the cases that was given to us this morning by your adversary, the Goldfeder case, which addresses that kind of issue. I think it actually addressed the issue of fair market rent appeal. That was actually done on summary judgment, correct?
Correct. 2 of the cases from this morning.
So that we have appellate authority from this court that's contrary to what your adversary said with respect to the so-called routinized way of making a pre-answer motion to dismiss in these kind of cases.
Right. Correct. And I'm sorry, you had asked a question, and now it is.
It's okay, I've keep going.
Okay, I just want to briefly note the only remaining other questions are whether Regina changes any of this. And of course it doesn't. If Regina was going to upend 15 years, in a J51 case nonetheless, 15 years of well-settled authority that landlords have to prove deregulation, it would have said so. The only passage that even remotely touches on it is on page 9, where the Court of Appeals seems to equate a base date rent with an annual registration statement. And as we pointed out in the brief, that just doesn't work. What the court really seems to be doing is just discussing the way it thinks DHCR functions. It's not establishing a new rule of law. And oh, by the way, if it did, Regina itself would violate Regina by changing the burden of proof and record-keeping requirements retroactively. Thank you.
Thank you. Counsel, I believe you have 2 minutes in rebuttal, yes?
Your Honor, the best indication of why this pleading is ultimately a boilerplate pleading that does not comply with Grimm goes to the contemporaneous IAI or the contemporaneous plaintiffs. These are plaintiffs who lived in the units at the time that the alleged IAIs were performed. They had the ability to observe or not observe what happened firsthand. And yet the pleading with respect to that group of plaintiffs as well is completely boilerplate. And this is why these kinds of motions get decided on motions to dismiss all the time.
No, but, respectfully, a tenant can see improvements in an apartment or work being done in the apartment, but they never get the bill that says it's 8 times what it should have been, or that information isn't given to them. So the fact that they don't particularly have that information is neither surprising nor.
But Your Honor, in this case, that's not the nature of the claim. In this case, the nature of the claim is the work never happened. And my point simply is that for the contemporaneous IAI plaintiffs, if they were living in a unit and work never happened, and all of a sudden the next day the rent went up $3,000.
Same thing. They don't see the bill where a contractor bills for 35 things and maybe painting was done or something to that effect. It's not, my point is, it's not surprising that the tenants don't have that particularized information.
But Your Honor, they should be able to plead more than the boilerplate that was pled here.
But aren't you arguing against yourself? Maddox tells us that a motion to dismiss should not be equated with a motion for class certification, and you're arguing the different subgroups within the putative class. More information will be discerned at discovery, won't it?
Oh, more information is always available in discovery, Your Honor. But the point is, I see that my time is up. May I just briefly respond? But the point is, Your Honor, is that statutes of limitation questions get decided on motions to dismiss all the time. Because you look at what the pleading has. You look at whether or not the pleading reaches the level that the law requires. And here, this pleading doesn't.
Thank you, counsel. Thank you both. Zelig versus DHCR. Whenever you're ready, Counselor.
Thank you. Good afternoon, Your Honors, and may it please the Court. My name is James Fishman for the appellant, Irma Zelig. I would like to retain 1 minute for rebuttal.
Okay.
The motion court got this case wrong twice. Not just once, but twice. The first time, she upheld this order of deregulation in the face of demonstrable evidence that my client had in fact filed a tax return, it was timely filed, and it was below the threshold. She had that evidence. She ruled against her anyway. Then, after that, we were able to locate somebody at the Department of Taxation and Finance. Deep within the bureaucracy of that agency, we found somebody and we said, look, this woman's going to get evicted because you guys got it wrong. You sent a letter to DHCR in 2014 that said this woman did not file a tax return. You gave that letter to DHCR. They relied on that letter, and they deregulated her apartment.
Your client never filed or submitted the necessary documents or tax returns in order. She never submitted her tax returns.
Well, Judge, she submitted a lot of things. She submitted
Did she submit anything that was relevant to the issue as to the apartment?
I'm sorry, I didn't hear the
Did
first
she
part.
submit any documents or information that was relevant to the issues as to her tenancy in the apartment?
Yes, a lot of information was submitted. First of all, she stated under oath in both the answer to the ICF and in the answer to the petition, I made less than the threshold, the $175,000 threshold. That's the starting point. So she never
Mr. Fishman,
defaulted.
I'm sorry. In answer to what the Justice presiding was answering you, and something that you said earlier, and this is, I need clarity here. Would it be a fair statement that all the relevant documentation that was ultimately submitted to arguably establish that in 2009 and 2010, her income didn't meet the $175,000 threshold, was submitted for the very first time during the Article 78 judicial review proceeding? Yes or no?
No, no, as I said, she stated under oath, my income was below the
No, no,
threshold. She's,
The fact that she stated something is self-serving. The law is clear, based on well-settled case law and regulation, that when one is challenged in a deregulation petition, they had an affirmative obligation to competently submit either tax returns or other competent proof, or explain exactly why they couldn't submit tax returns. Bear with me. It is undisputed on this record that nothing was done for 6 years. Yes, she did submit stuff. Yes, she did answer. We're not saying this was a total default. The issue is, did she default in submitting the appropriate documentation for DHR to determine whether she exceeded or not exceeded threshold? So, in answering my question, the relevant documentation, the either proof of the 2009 tax return filed in 2010, the psychiatrist letter, the affidavit by the alleged DTF data processor, all that stuff, forgive me, was all that submitted at the rent administrator's level, yes or no?
no, it was not, Judge, and I
Bear
think,
with me, was all that submitted during the processing of the petition for administrative review?
it was submitted on a request for reconsideration
Right.
at the DHR level.
And at that request,
Yes.
the commissioner's order was issued in June of 2018. I assume it was you, forgive me, I didn't memorize the record, but I assume she retained you as counsel at the time.
For the 78.
Right. Oh, for the 78.
And, well, for the reconsideration.
Fair enough, that's what I mean. And when you made your request for consideration, that was done in August of 2018, 2 months after the final commissioner's order. And the DHCR sent you a letter in August of 2018 that found no basis for fraud, illegality, and irregularity of matter to reopen the PAR or the whole proceeding, correct?
That's correct.
So then you commence your Article 78. You commence your Article 78.
Yes, yes, that's correct.
And then that stuff resurfaced, not as part of the administrative return, because it wasn't part of the administrative.
There was no return, because DHCR cross moved to remit. They never
Okay,
put
so
in a
then,
return.
counsel, the question again is, what was submitted other than her statement that she made less than the
She put in
threshold?
letters, and she put in materials from her returns. She put in her extension document, which they could have used to
Did the extension document show an income?
no, but it showed how she filed the return.
So then again, the question is, between 2012 and 2018, what relevant, statutorily approved, for lack of a word, document did she submit?
Well, Judge, I submit that
I just want
if-
to know.
Answer, if you could just answer the question, was there anything submitted regarding her income and the fact that it was below the statutory threshold other than her
He
statement?
repeatedly said, I don't make that much money, and DHCR knew from previous, there were 5 or 6.
I could say I
prior
make $2
proceedings.
million. It doesn't really, I mean, it has no
Judge,
basis.
I think we have to
And
consider,
after,
though,
at the
who
term,
is-
excuse me, counsel, the term of the reconsideration, at the time of the reconsideration, there had been a final determination, is that correct?
at the time of the what?
Reconsideration, the request for
You mean
reconsideration.
Our renewal motion?
Yes, your renewal motion.
On the renewal motion, we didn't have an affidavit from the tax department admitting they.
No, my question was, there had been a final determination, is that correct?
There was a PAR decision.
Thank you.
And DHCR wanted to remand it, which is granted routinely. When DHCR says there was an error, we recognize there was an error, they joined us.
Thank you, your time is up. You have rebuttal, yes? Yes, you do.
Good afternoon. If it please the court, Paul Gruber from Borough Goldstein for the intervener Aspenley Company. I'd like to start with a sentence from Judge Bluth's first decision in here in this proceeding. The entire rent stabilization system is built upon both landlords and tenants following the rules.
So, counsel, I'm going to ask you some very simple questions. Courts, of course, have the judges have the ability to reconsider their own decisions, right? And agencies also have the right to reconsider their own decisions. Here, where DHCR says that it wishes remittiture so that it can reconsider the situation, reconsider the deregulation of an apartment that's been resided in for 40 years, more than 40 years by this tenant. Why is remittiture improper?
Because the right to remittiture of a proceeding to an administrative agency is not that broad. As this court made it very, very clear in Peckham versus Calogero, which was affirmed by the Court of Appeals, that DHCR isn't allowed to ask for a do-over. If there's fraud or irregularity in a vital matter, then that's one thing. They can ask for that. But that's not what they asked for here.
So here we're
They
not
said it was
talking- Here we're not talking about someone who, here we're not talking about property. Here we're talking about an apartment and a tenant, and it's a long-term
And the apartment is
stabilized
property.
tenancy. I would,
Counsel, just,
Sorry.
please.
thank you. So here what we have is failure to submit information about tax returns, but there's a treating psychiatrist's letter that says, my client, my patient, has been suffering from basically clinical depression and has been unable to take care of her affairs, has had to wind her practice down. She will get everything done, and lo and behold, there was information provided to DHCR with respect to the tax return. Why is the agency not able, under these specific conditions, to reconsider its decision to destabilize the apartment?
This all happened after the agency rendered a final determination. The court in Rizzo says that you cannot look at new factual developments after the agency has rendered the final decision. She had 10 opportunities to submit whatever she wanted, and what she should have submitted, according to the DHCR regulations, was either the pre-printed label on her New York State tax return or the front page of that. None of that was ever submitted.
And what you're saying is that the diagnosis included in the psychiatrist's letter, to wit, major depressive disorder that is severe, that cannot be taken into account?
That was filed in an earlier proceeding. It wasn't referenced in this proceeding until the request for reconsideration, the denial of which is not properly before this court, and an unsworn letter that we haven't had a chance to investigate, certainly from now 10 years ago, certainly is not something that would constitute fraud or irregularity in a vital matter.
So your position is that once a petition for administrative review is denied, that's it? No remittiture is possible?
No, it's not. It's possible, but it's a very, very high showing, and we contend in the brief that that showing certainly was not made here. Can't we do it for a do-over?
Counsel,
Yes.
this is Judge Scarpullo. So you're saying that there was no fraud, there was no illegality, and those are the situations under which you could remit back with all this information that was probably in the woman's possession prior to 2018, but never submitted.
We don't know what was in her possession, to tell you the truth, and she doesn't really say what she had at that time. I see my time's up. Could I just finish the question?
Yes.
Thank you. There certainly wasn't any claim that anyone committed a fraud here. There certainly isn't any claim that there was any illegality in the process. Luxury deregulation was on the books. The landlord followed all the proper procedures, and the record shows that the agency, until it had this change of mind, certainly followed all the proper procedures. The Court of Appeals has made it clear in the classic case that in an LD matter, you're not entitled to a do-over because of something that you do after the fact of the determination. I ask that the court affirm.
Thank you.
Your Honor, a few points. First of all, this is not a classic realty case. That involved manipulation. I'm sorry?
This is not a...
Classic realty, the case that Mr. Gruber just cited. That case involved manipulation of people hiding their income. Nobody hides their income when it's under income.
So, counsel, what would permit us to remit the matter?
what would permit you. You're absolutely entitled, you absolutely can admit. In fact, you did it in the Partman case just this year where you reversed Judge Bluth on another DHCR case where you said they can take it back for a new decision even after a final determination. This is not a high standard. It happens all the time. When DHCR recognizes that this should be looked at again, the agency is entitled to that deference, and they should be given that deference when they say, we'd like to have it back. And then when
Counsel,
DHCR...
let me ask you, how do you respond to the argument that after the final order, the only way you can remit it back is through fraud or illegality?
It's irregularity, Your Honor.
Irregularity. What's irregularity?
This is an irregularity when the tax department admits that they made a mistake. How much more of an irregularity can you imagine? A state agency not only makes a mistake, but then comes forward and admits it in a court proceeding? I've never seen that in 40 years of practice, Your Honor, that a state agency would come forward and say, yes, we made a mistake. And not only did we make a mistake, this woman is facing eviction because of our mistake. And DHCR relied on that to its detriment, and my client is now the one that has the detriment from that mistake. And 7 of the 10 notices that counsel references never would have been sent out in the first place if DHCR had been given the correct information in the first place back in 2014.
Or if your client had provided the information.
Well, I understand, Judge, but...
Thank you,
that's
counsel.
what
We have your
happened.
briefs. Thank you very much.
Thank you for your time.
Barbado versus Giason. Whenever you're ready, counsel.
Good afternoon, Your Honors, and may it please the Court. This case is about an allegedly libelous series of statements typed on a keyboard in Missouri. The case belongs in a circuit court in St. Louis, Missouri, and not on the docket of a New York court. Now, there are 2 big picture points I would like to surface for the Court's attention this afternoon, and they're critical. First, the motion court's order regarding personal jurisdiction failed to separate out the libel claim in this case, and particularly the libel claim against Melinda Giason, from the other torts in the complaint. And that's a problem. By statute, libel claims are expressly carved out of long-arm jurisdiction pursuant to CPLR 302A2 and 302A3. Absent another basis for jurisdiction, there can be no personal jurisdiction over Melinda Giason with respect to the libel claims. Now, to get around the defamation carve-out, respondent relied upon a 1980 Southern District case, Dixon versus Mack, for the proposition that Mr. Giason could be seen as an in-state agent for Melinda through the so-called conspiracy theory of jurisdiction.
Counsel, just one clarification. But you're representing both clients.
Correct.
Even though you said that there's a distinction between the husband and the wife, the conduct of the wife and the conduct of the husband.
Well, on the record, there is a distinction between the two. The principal
But I'm asking, but you're representing both.
Yes.
So they're united in interest?
They are.
No conflict there?
None at all. The distinction I'm trying to draw is particularly between, well, for purposes of the libel claim, I should also point out that the libel claim against James Giason was dismissed. So we are now looking at the libel claim against Melinda Giason.
The libel claim as to Melinda wasn't dismissed as well?
It was not. And that's what's interesting, because under the CPLR, it had to have been. And what the motion court did, which was error, was it tried to get at the libel claim for jurisdictional purposes through the conspiracy theory of...
I thought some of the libel claims as to Melinda were dismissed as time barred.
Some were, but not all. And they all should have been, because the workaround that the motion court entertained erroneously under the Dixon v. Mack case involved conspiracy. And conspiracy is just another word for agency. As we all know, under the long-arm statute, liability, jurisdiction can be based upon a person who, in person or through an agent, committed one of the enumerated tortious acts. And the problem with that is, I think that if the Dixon v. Mack case involved civil rights deprivation, I think that if Judge Sand in the Dixon case had a defamation case before him instead of a civil rights case, he'd have bounced it right out of court. He wouldn't have even gone through the multiple factors for deciding whether or not a conspiracy was satisfied.
There were 2 orders of protection against the husband, right?
There were.
And both of them said that there was to be no third-party contact with the plaintiff?
That is correct. That is in the
But
record.
there was an onslaught of emails from the wife, no matter what?
The complaint alleges what it alleges, and it alleges all of those things. My point is, for purposes of libel, jurisdiction can't be had over either Melinda or James. And let's take it for a moment through Dixon, because there's a 3-pronged test for agency. Let's assume I'm wrong. I'm not. But let's assume for a moment that 302A2 didn't categorically bar jurisdiction over a libel claim. Still doesn't work under these facts. Dixon requires 3 things. It requires that there be an awareness on the part of the out-of-state defendant of the conspiracy. There was no conspiracy in existence when Mr. Giason was physically present in New York.
But she knew, apparently, that he was engaging in this conduct with the plaintiff.
Well, not during the jurisdictionally relevant point. In order for you to be subject to jurisdiction for the acts of an in-state defendant, those in-state torts have to have been taken place in furtherance of the conspiracy. There was no conspiracy before.
So, counsel, you only have a little bit more time. What about the intentional infliction of emotional distress in terms of Mr. Giason?
Well, in terms of Mr. Giason, that's a separate matter. That of course, doesn't require looking at the libel statute, but
Did his actions rise to that level?
No. I mean, between June and July 1st, when he was in New York, he was just trying to pursue a woman. This is not exactly what we would call outrageous conduct. I would just like to say one thing.
The wife thought it was outrageous conduct, counsel, didn't she? The wife thought it was outrageous conduct.
The wife thought that what Mr. Giason did when he was in New York out of her sight was outrageous. Certainly she was upset about it under the facts of this complaint.
She sent Instagrams to the plaintiff saying, hashtag sleeps with married men, hashtag homewreckers, hashtag adulterers. No, sorry, I split it up. Hashtag adulterers, hashtag sleeps with married men, hashtag homewreckers. She made up a whole lot of stuff here. And then the husband joined in. So saying same ugly dress, same ugly jewelry, that may be considered petty. But you persist in saying that they're not united in interest and that this was not intentional infliction of emotional harm.
Well, I would say that it doesn't rise to the level of IIED, and if it did, every instance where a person engaged in social media could wind up opening the floodgates to the doors of the court. I do see that my time is up. If I could just say one more thing in concluding.
No, thank you very much, though, counsel. We have your briefs. Thank you.
Thank you, Your Honor.
Next case is Way versus NASDAQ.
Good morning, Your Honors. May it please the Court, Jonathan Lupkin from the firm of Lupkin PLLC. Before I begin, I'd like to reserve, there's an appeal and a cross appeal.
You have 10 minutes.
Yeah, I'd like to reserve 4.
I'd like to reserve 3, Your Honor, on my cross appeal, if that's permissible.
Sure. It would be helpful if you stated this prior to the calendar call, but that's okay.
I did,
I'm sorry,
Your
how
Honor.
much did you want to reserve, counsel?
4.
4, okay. Thank you.
Thank you. Your Honors, this is a state law claim involving 2 private parties. My client, Benjamin Way, and on the other side, defendants, which are a NASDAQ, a for-profit, multi-billion-dollar company that is itself listed on the Fortune 500. We have substantial history in this case, even though we're just at the pleading stage. And the main argument that the defendants advance has to do with the issue of immunity, whether or not, as an SRO, a self-regulatory organization, NASDAQ is entitled to immunity.
Exactly. So why is it not an SRO?
Well, there is one of the entities is an SRO, but not all conduct by SROs are entitled to immunity. There are multiple defendants here, but even if you focused exclusively on the SRO for the moment, it doesn't matter because there is authority in the Second Circuit and around the country that make clear that the touchstone for what is appropriate by way of immunity is whether or not the SRO was exercising a regulatory function. And here we're not writing on a clean slate. This case has been before the federal courts already, and they've also been in front of the trial court. And both courts independently concluded that there is simply no regulatory function that was being performed here. What is alleged in the complaint in the 57 pages is that NASDAQ reached out and went out of its way for its own commercial interests to
Wait, counsel, you're saying that there has been a finding in this case by another court?
No, what I'm saying...
By a federal court?
No, that's not what I'm...
Why are we here if that's true?
If only. No, that's not what I'm saying, Your Honor.
What did you just say?
What I'm saying is that there was a removal to federal court. We made a motion to remand.
And then it was remanded back. But that doesn't, the fact that it was remanded back doesn't at all affect the determination of whether or not NASDAQ was acting in its regulatory function.
Right. And true enough, but it does give some insight as to whether or not they were acting in a federal regulatory capacity, because Judge Keenan does speak on that issue. But putting that issue aside, if you look at the City of Providence case, the touchstone of whether or not one is entitled to immunity is whether or not they've exercised a regulatory function. Here, there was no regulatory function being exercised. The allegations...
Even though the allegation is that they made statements to the FBI, the U.S. Attorney's Office, and the SEC?
That's correct.
How is
And
that
in
not a
that regard, it's similar to the... I'm sorry, go ahead, Your Honor.
How is that not exercising your regulatory function?
It would be no different than if I went to the SEC or the FBI.
You're not NASDAQ.
No, I understand that, but Mr. Way was not subject to NASDAQ's regulation.
What did they say to the FBI, the SEC, and the U.S. Attorney's Office? What did NASDAQ tell them?
They alleged that Mr. Way and his companies engaged in a scheme to defraud whereby they hid beneficial ownership of shares and that they violated the so-called 300 round lot rule by gifting shares to various individuals.
And what is NASDAQ's role? What are they there for? Are they not concerned with regulating, controlling the shares, and also controlling and regulating the 300 round lot rule? I mean, it's their rule.
Well, yes, except there's a critical distinction here, Your Honor, and that is the allegation is that the 300 round lot rule was violated because of the gifting of shares. And what is absolutely clear on the record, and I don't think that the defendants will dispute it, is that there is no prohibition on the gifting of shares. And so what Judge Borak found...
But then your argument goes to the application of the rule, not the function of the NASDAQ.
No, there is no contention that the 300 round lot rule prohibited gifting, period, full stop. And the allegation essentially made up is that there was a prohibition on gifting 300 round lot shares to various people. And that simply didn't exist. It doesn't exist by anyone's concession. And so the question is...
No, wait a second. May I just interrupt you, counsel? Isn't it that it was a fake gift? That it wasn't really a gift? It was set up to look like a gift, but it wasn't for the purpose of getting around the rule?
No, Your Honor. I don't believe that that's right.
Okay.
There are actually two facets of the allegation. One is that they violated the no gifting rule, which never existed. And two, as a factual matter, that Mr. Way disguised these shares and spread them around so as to hide the beneficial ownership. And Mr. Way is not
And thereby control and manipulate market price.
that is the allegation. And the question is whether that's true.
Isn't that concern properly expressed to the FBI, the U.S. Attorney's Office, and the SEC?
Yeah, but not subject to absolute immunity, because the touchstone of absolute immunity here is there existing some sort of procedural safeguard, a procedural mechanism. This case is most closely analogous to the D'Alessio case. And the critical distinction in D'Alessio, where there was a referral to the FBI and the U.S. Attorney's Office, is that A, D'Alessio was a member, and B, he was participating in a regulatory disciplinary proceeding in which he had the opportunity to challenge what was being said about him. Mr. Way never had any such opportunity to do that. And that is the critical distinction here. The only issue in this case is whether Mr. Way was lied to by, whether or not NASDAQ lied to the FBI and the Department of Justice about whether or not Mr. Way committed crimes. Period. That's what this is about. Mr. Way is not subject to the NASDAQ regulation. He had no wherewithal to challenge the opportunity.
You have 4 minutes on rebuttal.
Thank you.
I'm sorry, Counsel, how much time did you want to reserve?
I'll take 4 minutes also, Your Honor. Thank you so kindly. Robert Serio for the NASDAQ defendants. May it please the Court. Plaintiff's claims fail on multiple grounds, but I would start with immunity, as my adversary has. And the issue here is that the plaintiff's claims are wholly barred by the doctrine of immunity because this case involves NASDAQ performing its regulatory responsibilities.
Your adversary, however, just left off by saying that it doesn't, that grant of immunity is not absolute, and that apparently in this particular case, the statements made by NASDAQ were false.
Well, Your Honor, plaintiffs themselves have conceded that NASDAQ and its officers would be entitled to absolute immunity from damage suits in connection with the discharge of their regulatory responsibilities. And the question is, was NASDAQ discharging its regulatory responsibilities in connection with interpreting, enforcing, and referring potential violations of the 300 round lot rule for potential enforcement by the SEC and other
So was there in fact a violation? Well, actually, I thought the argument was being made that there was no such rule in terms of that, a prohibition of that.
I understand, Your Honor.
Trading.
So there is a 300 round lot rule, and plaintiffs' claims require that rule to have been violated by NASDAQ through falsely claiming that plaintiffs violated it by gifting shares. And the reality is that to interpret that NASDAQ's regulatory responsibilities, including interpreting that rule, the text of the rule is not in dispute. When one looks at the rule, there can only be, a company can only be listed if 300 different shareholders own at least 100 shares each. It is implicit in that rule, and NASDAQ has always interpreted that rule, that you need 300 independent beneficial owners making independent investment decisions. And that is because the purpose of the rule is that there be sufficient depth of interest in the stock to ensure that there is liquidity.
Mr. Judge Scarpullo, so your NASDAQ interprets the rule and says, under our interpretation of what he's doing, we think this is a violation and we're going to report it to this, this, and this. And it's your position that that is part of its regulatory function, correct?
Absolutely. NASDAQ is charged with interpreting its rules.
And what about counsel's argument that because it was remanded from the federal court, for some reason it doesn't, for that reason it doesn't implicate the regulatory function?
Judge Keenan was deciding a different issue, Your Honor. He was deciding whether on the four corners of plaintiff's complaint they stated a federal issue. The issue for this court, it goes to NASDAQ's defenses. It has
Let me just get, if you're right, I can apply the immunity the same way the federal court could.
It's a matter
That
of
what
common
you're
law.
saying to me?
And Your Honor, I mean, I'm not aware of
Or we, not me.
I'm not aware of this court interpreting the immunity doctrine. The Court of Appeals in the Guisi case has applied the preemption doctrine to dismiss a case against brokers. But just to return to Your Honor's question, whether the interpretation was proper or improper, whether NASDAQ made up the rule or made up its interpretation, that is all entirely within the scope of its regulatory function. If a plaintiff can come into court and say NASDAQ made up a new interpretation or a false interpretation or lied, immunity would have no value whatsoever. Indeed, this case is on all fours with the D'Alessio Second Circuit case, where the plaintiff in that case was a member, although determinations of immunity do not turn on membership on the SRO. They are not limited to just the SRO. It covers officers and directors. And in the D'Alessio case, the member of the New York Stock Exchange asserted that the exchange made up an incorrect interpretation of its rules and then advised the plaintiff of that interpretation. He followed it by flipping shares in violation of SEC rules. And then they alerted the authorities, and he was prosecuted. And the court said it doesn't matter whether the SRO is acting properly, improperly, fraudulently. It doesn't matter what its motive is. It doesn't matter if it's a profit motive. All that matters is the conduct functionally part of its regulatory duties? And there is no doubt here, under the DL Capital case, under the New York Specialist case, decided by Justice Sotomayor when she was a judge of the Second Circuit, she herself recognized that there cannot be a fraud exception to immunity, or every every plaintiff is going to claim that there was something fraudulent, no different than if a prosecutor could be sued by a defendant for fraud in prosecution of the offense. I will reserve the rest of my time for rebuttal then, Your Honor.
Your Honors, obviously I'd like to spend time on the malicious prosecution claim, but there are a couple of issues that remain glaring here on the issue of immunity, and I want to address those. During the interplay between counsel and the court, there was an observation that they've always interpreted the 300-round lot rule as prohibiting the gifting. That's not true, and in fact, the complaint speaks precisely to that issue at paragraph 105 of the complaints found on page R112. There were specific questions posed by Mr. Way and his colleagues as to whether or not it would be a violation of the 300-round lot rule to gift shares. And the answers that they were given were no. They were not violations. And so the notion that at the very least that's a factual question. If they were advised by staff members of NASDAQ that it doesn't violate the round lot rule, it's going to be very difficult for them to come in now and say, I'm referring you to the criminal prosecutors because you violated the 300-round lot rule. But putting that aside, the only thing, that's point number one. Number two, in the suppression hearing itself, which is discussed.
I'm sorry, was there any evidence that this had been asked of NASDAQ as to whether or not there was, in fact, a round
Yes,
rule?
we pleaded in the complaint, Your Honor, that specific questions were asked of NASDAQ, and they said, no, this is not a violation of the 300-round lot rule. And let me just point to you, it's page 112 of the record, paragraph 105. But there's another point here. When Judge Nathan, who decided the suppression hearing, pressed the U.S. Attorney's Office about whether or not there was a 300-round lot rule violation by gifting of shares, he couldn't identify any such rule. Let me say that again. He could not identify. He was on the stand, and Judge Nathan specifically asked him that question: where is the prohibition on gifting shares as a circumvention of the 300-round lot rule? And he could not identify it. And we discussed that in our brief on page 35. And finally, there is in the papers a reference to a release, 1415, in which NASDAQ purports to interpret the 300-round lot rule as prohibiting the gifting of shares to satisfy that rule.
Counsel, there was no formal acquittal of your client in the federal prosecution, correct?
He was neither acquitted nor convicted.
Right. It's sort of like ended neutral, and I'm not going to, and I understand your point that based even on state appellate case law, you can commence a malicious prosecution case here, even on the grounds that that case sort of got tossed out, neither here nor there.
It's guilt neutral. I assume you're talking now about the malicious prosecution.
Correct.
component.
That's why you're about to discuss it.
Smith-Hunter, which is the dispositive case in the Court of Appeals, makes clear that in order to satisfy the favorable termination requirement, it just has to be guilt neutral. The reason that the Martinez case, which is cited by Gibson-Dunn, is inapposite here is because there was a reversal for suppression of evidence after guilt beyond a reasonable doubt was established by a jury. In this case, Mr. Way did not have an opportunity to challenge that evidence. It was all suppressed, and the charges were dismissed. The government had any number of options available to it at that juncture. It could have appealed the decision. It could have narrowed the scope of the evidence, but it chose not to do any of that, and instead what it did is it filed a nolli prosequi, which in the Smith-Hunter case itself, Chief Judge Kaye explicitly identified as the classic case of a guilt-neutral determination. Unless the court has any other questions, I'll rest on my brief. I do want to actually point on just one other thing. Going back to the 1415, which I started to talk about before, that release of interpretation on the 300-round lot rule was only made days after Mr. Way's conviction, Mr. Way's indictment was dismissed. It was not in existence at any point in time earlier. Thank you very much.
Thank you.
Your Honor, the fact that plaintiffs may have pled in their complaint that certain individuals at NASDAQ may have offered their own views on the 300-round lot rule, it does not make the conduct of NASDAQ in interpreting and enforcing and referring any less regulatory. And immunity covers conduct which may be improper, it may be proper. In this case, NASDAQ's rules include a Rule 15101, the preamble to its rules, which specifically notes that with regard to its listing rules, that because NASDAQ has the responsibility as an SRO to promote just and equitable principles of trade, it may use its discretion to deny listing or apply additional or more stringent criteria for the initial or continued listing of particular securities based on circumstances that exist or occurs that make the continued listing inadvisable or unwarranted. This is because it is a regulatory function. And so at any time...
Counsel, may I ask you whether the nolle prosequi filing by NASDAQ has any impact on the regulatory function, the regulatory immunity that you are arguing?
No, Your Honor. So my view...
I don't want to conflate the two.
No, exactly, Your Honor.
But I need to ask you that.
Yeah, so I think that those are separate defenses. In other words, my view is that NASDAQ is absolutely immune. The claims are fully preempted. But if we put those arguments aside for purposes of argument and just focus on the common law malicious prosecution claim, here the termination was inconsistent with Mr. Way's innocence. The Court of Appeals has explained in the Catalano case that the analysis turns on the circumstances of each case. And in this case, the dismissal, there was a mountain of evidence set forth in the indictment against Mr. Way. It was dismissed because all of the evidence was suppressed on the basis of an overbroad search warrant. But however, the government did not think that there wasn't a claim against Mr. Way. Indeed, it prosecuted his co-defendant, Mr. Urbeck, who pled to aiding and abetting so-called individual number one, who could only have been Mr. Way. The government continued to believe in its case. It just couldn't use the voluminous evidence that it had against Mr. Way. And so we view that under the law as inconsistent with Mr. Way's innocence, which is the standard. Likewise, the other element of malicious prosecution here is that they have failed to adequately plead the absence of probable cause, because the NASDAQ's alleged statements are referred to only in 2 paragraphs of the complaint. They're mere surplusage. There is probable cause galore based on conduct wholly different from what NASDAQ allegedly said. NASDAQ's alleged statements were focused on the 300 round lot rule. What the government charged Mr. Way with was violating Section 13D of the Exchange Act for not disclosing his beneficial ownership of more than 5 minutes. But so the common law claim should fail, but more importantly, all charges should be dismissed, all claims should be dismissed with prejudice because of the absolute immunity of NASDAQ to claims like this that arise from its interpretation of its listing rules, its enforcement of those rules, and its referral of matters to the authorities. It's exactly on all fours with the D'Alessio case of the Second Circuit, and I would request that Your Honors dismiss with prejudice.
Thank you.
Thank you very much.
Brightman v. Sim.
Good afternoon, Your Honors. May it please the Court, my name is Carl Lustig. I represent the appellant, Lori Brightman. This is a case involving a dismissal by the lower court of my client's case on an issue of timeliness under CPLR Section 217C2, 214C2. First of all, the defendant's motion was procedurally defective. It did not contain any support whatsoever for why they contend that my client's condition was discovered beyond the statute. What the defendants do is they go through my client's record and they throw all of her various multiple medical issues, and there certainly were many, on the wall, and then they contend that those were items that existed prior to the commencement of this action, prior to the 3 years in this action.
So, counsel?
And,
Counsel?
no, I'm sorry.
Are we contrasting the date of the onset of symptoms, which at the latest would be December of 2011, I believe?
That's
to,
what the
to the
defendants...
diagnosis for the mold, which is January of 2012?
Yes.
Is that the big difference?
That would be the earliest date that the statute would commence, which is within the 3 years of commencement of suit.
The earliest would be January 2012?
I'm sorry, January 12th,
January 12th, 2012.
2012.
Right, January 12th, 2012. And
Correct.
so she became aware of the symptoms and the condition in December, did she not?
No, that's not correct, Your Honor. She was having certain issues, but this is a lady who had a history of allergies and other problems that could have been attributed to a multitude of things, including cats and the other things that she was allergic to, which is in the record. Ms. Brightman went for the obvious problems that she was having, saw that doctor. That doctor casually said you should have your apartment checked out, which she ultimately did. However, that was not the primary diagnosis which triggers the running of the statute. The primary diagnosis under the New York DES litigation, Wetherill, the primary diagnosis is when you have a reasonable understanding of what the diagnosis is that then reasonably triggers the statute.
But
Ms. Brightman...
Counsel, is that what case law says? Or does case law say that the 3-year statute of limitations runs from the time that a plaintiff discovers an injury, which is to say from the time she or he has a physical manifestation of the illness, regardless of when the cause of the illness is learned?
Well, that is correct,
And
except
I'm not saying that I like this, just so you know.
I'm sorry.
I'm not saying that I like this, but isn't that what the case law says?
Well, Your Honor, there's case law
And I'm
that has
quoting
come
Martin,
down subsequent
First
to
Department,
the
2004.
to the DES case that has not directly addressed what is the quote-unquote primary condition. What we're doing here, what I'm saying here is that my client's primary condition was not diagnosed. There was no symptomatology, there was no progression of her issues for 3 or 4 months after she saw the allergist in 2011. She immediately started seeing doctors for her problems, and she saw doctors for over 15 months, none of whom once ever mentioned mold as a potential cause of the issues.
I thought there were references to mold in the medical records from 2011, 2010, 2009, 2010, toxic mold exposure. Record shows references to mold in her medical history in April 2012.
There were references to mold in her medical history, but they were not mold that was producing any symptomatology. Dr. Brightman...
I don't understand. So there's certain mold that's going to produce certain symptomatology and this other mold that's not going to, and how would you distinguish between the two?
Well, how I distinguish between the two, Your Honor, is very simple. The exposure to mold, which is not producing symptomatology, does not trigger the statute because that is not a primary diagnosis of a manifest problem. She continued under the care of a multitude of doctors, cardiology, gynecology, hematology, pulmonologists, neurology, and immunology for 15 months. For 15 months, and not once did any of these doctors ever suggest that there was mold involvement in the case.
Well, so wait, I know you have, are you saying that you have to be diagnosed? That's what you seem to be saying. Until you're diagnosed with mold infestation, then the statute doesn't begin to run. Well, that's what we're struggling with here.
I understand that. Now, there's a subtle distinction between an actual flat-out diagnosis and arriving at what the primary condition is. But arriving at the primary condition cannot be interpreted as something that's out there and that's part of what's going on with you, maybe, when there are all of these other medical problems out there. Now, I'm not saying, I would agree with the court, that you really can't call it a definitive diagnosis. That's not what triggers the running of the statute. But what does trigger the running of the statute is when you have a pretty clear idea of what your problem is, irrespective of what caused it. My client was seeing doctors for a multitude of problems, not related, that were the doctors in differential diagnosis did not relate to mold, and therefore she had no idea what the primary cause. And to quote the Court of Appeals in the DES case, The court says what triggers the statute is the primary cause. This isn't an imaginary cause. This isn't something that's out there as a potential differential diagnosis. This is something that is a primary cause.
Thank you, Counselor.
Yes, Your Honor. Thank you.
Good afternoon, Your Honors. Meryl Biscone from Rifkin Radler, and I represent the respondent in this matter. A review of the record here reveals that plaintiff's symptoms, illnesses, injuries all manifested itself before the operative date. Case law emanating from this court.
Sorry, counsel, I'm not hearing you clearly.
Is this better? Case law emanating from this case does not reference the primary condition. The 3-year statute of limitations runs from the plaintiff's discovery of the injury, which is the time she realizes that she has the physical manifestation of illness, regardless of when she learns the cause.
Well, what your adversary is saying, that, as I understand it, is that she didn't have one symptom. She had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 symptoms, and I'm making up a number. And she really didn't know what was going on. Therefore, she doesn't really know which symptom is causing what until she gets a proper diagnosis that says, all of these things equal a mold problem.
Unfortunately for the plaintiff, that's irrelevant for the purposes of the statute of limitations. It's when the plaintiff experienced the physical manifestation. It's irrelevant whether there were numerous causes, numerous diagnoses, numerous illnesses. That's what the case law from this court and the Court of Appeal says.
So counsel, this Judge Scarpello, so you're saying that the symptoms that she later attributes to mold, she was starting to feel 2009, 2010, there are indications of mold and manifestation in those records, and certainly 2011. So that's when the statute...
Correct. In 2010, they mentioned mold. 2011, they mentioned mold. Even if they didn't mention the mold, that's when the physical manifestation of her illness began. And that was before.
I'm sorry. What about her doctor, her treating neuro, who says, Dr. Younger, who says that it's exceptionally difficult to make a diagnostic connection to mold exposure. And in her case, doctors continue to do differential diagnosis. Are you making a distinction between diagnosis and symptoms, onset of symptoms?
Again, according to the case law, it doesn't, the relevant factor is not the diagnosis. It's when the physical manifestations of the illness begin, regardless of the diagnosis. That's what this court said in Martin and in Harley and in Vincent, and we invite you to look at that case. There's nothing about the diagnosis. It's when the physical manifestations of the illness begins. And here, that was 2010 and 2011, well beyond the statute of limitations. We'll rest on our brief. Thank you.
Thank you. Thank you both. Bio versus Beacon Broadway. No hurry, take your time. We're good? You may proceed.
Good afternoon. May it please the court. Alexis Carter with Bongiorno, Monteglio, Mitchell, and Paul Mary for the appellants, the Beacon and MSG entities in this matter. This case arises out of a plaintiff who was a patron at the Beacon Theater. He fell ill in his seat with...
Yes, we're aware of the facts. So what duty, if any, was owed to the plaintiff by Beacon et al.?
So it is our position that there was no duty owed to the plaintiff beyond their duty to keep a safe premises. And that comes from the Court of Appeals holding in Gilson versus Metropolitan Opera. That the court held in that case that there was no duty to escort a patient who is infirmed despite the obvious infirmity, because it would place an undue burden on the theater. Here, the security officers from the Beacon Theater could not render any medical assistance. And in fact, there's no statutory duty for the Beacon Theater due to their seat number to provide any EMT services on the premises.
Sorry, due to their seat number?
Correct, due to the number of the seats. So
The number of seats
in the theater, yes.
The number of seats, capacity, the seating capacity
Correct.
in the theater.
So the statutory duty to provide an EMT on the premises would be triggered at 5,000 seats. The
So
Beacon
did
has
now
less.
Beacon undertake any type of, or assume any type of duty when they responded, when the security officer responded to the plaintiff and his wife when they were seated and he had passed out twice?
So assuming that they did take on a duty, the issue here, the main issue, is the fact that the plaintiff stated multiple times to numerous people, including the head of security, as well as the director of house operations, I can walk on my own. I don't need assistance. And it's our position that in doing so, that's where the buck stops. There was no way for them, if there was a duty, to fulfill that duty basically without committing a battery on the plaintiff. They would have essentially had to hold him, restrain him, or assist him against his will. And that's really the biggest issue here. There was no way for them to do it.
Is there anything in the record which would suggest that the plaintiff was incapable of making a, for want of a better phrase, informed decision that he did not wish to be assisted?
There's not, but actually there is evidence to the contrary. He, obviously, the Beacon staff cannot make a medical determination or assessment. However, they did witness him, meaning the plaintiff, having a conversation. The testimony from plaintiff's wife was that she spoke to him when he came to, and he said, no, I'm okay. The testimony from the EMT, most notably, she advised that she can make a medical assessment. He was alert, he was awake, he was oriented ×3, and in fact, he said, can we do this somewhere else? He was very aware of what was going on. So the evidence shows that he was able to make a conscious decision. There was no mental or cognitive impairment that's shown in the evidence anywhere.
Thank you. Any other questions? Thank you very much, Counselor.
Thank you.
I think he wants to go next. Whoever wants to argue next, just tell me who you are and you can argue.
That way you get to talk against all of us. That way you get to address all of us at once. It's fine.
Your plaintiff? Okay, yes, so he's correct. Go ahead.
Good afternoon, Your Honors. If it pleases the court, my name is Ed Guardaro. I represent TransCare, the EMT in this matter. I'll just jump right into the court's questions. Was there a duty? No, there was no duty. As my colleague pointed out, there's no duty under the circumstances, and in any event, he refused care. That goes to the second question the court asked. Was there any assumption of a duty? Even if there was an assumption because they went to assist the patron, it was outright refused. Ms. Forrester, who was the EMT, specifically asked him several times. She testified 3 or 4 times that she asked him. She even asked him when he got into the aisle, may I hold you? May I put my arm under, your arm? Absolutely not. He was embarrassed. It was sort of a self-conscious thing he said. I don't want this happening at all. The videotape, which I'm sure the court has seen, or at least seen the...
Counsel, 1 second. Justice Gonzalez has a question.
I'm sorry.
No, I want to ask you something. So you know the term refuse medical attention? What's the import of it here?
I'm sorry, Your Honor, I didn't hear that.
You know the term refused medical attention?
Yes.
What's the import of that here?
Under the circumstances here, you know, under the
I mean, this
Osmeyer
person is
case,
an
I believe it
adult,
is.
right? Counsel, the plaintiff is an adult. So is he authorized to refuse medical attention?
He is, Your Honor. The case law cited in all of the briefs demonstrate that the EMT does not have a right to override his refusal as an adult. She assessed the patron as clear thinking. There was no questions about that. He was just embarrassed. So I believe the law is on our side in the Fosmar case and even the Gilson case relatively to that issue of, as an adult, he has an absolute right, and Kowalski has absolute right to refuse medical attention. In Kowalski, unfortunately, there was a death. So the Court of Appeals went as far as to say, even where the circumstances are much more grievous, you can't stop somebody from refusing treatment. So in this case, I don't believe there was a duty to stop him either. So with respect to the third question the court asked, you know, was there anything, you know, about the question about making an informed decision? Again, I would reiterate that he made very clear to the EMT, Ms. Forrester, that he could make his own decisions. I mean, he even said, "I'm embarrassed. I don't want anybody seeing this."
But counsel, he had passed out twice while seated. I think when the EMS, Ms. Forrester, approached, I don't recall whether he was conscious or whether he was unconscious, but he did seem to be having some issues in terms of focusing. So wouldn't that perhaps lead to a conclusion that he was not able to actually make a determination that he could ambulate out but on his own?
Your Honor, I would submit respectfully that the record demonstrates no issues with focus, no issues with clarity of thought, none whatsoever. The testimony in fact, by the plaintiff himself. You know, he says, "I don't remember," but his wife says, "Well, I didn't hear the conversations, but I knew there were conversations." And the Ms. Forrester, as well as the Beacon's employees' joint testimony at this juncture is unrebutted about the clarity of his thought in walking forward. And as you'll see in the video, Ms. Forrester was literally within inches of him as they were walking up the ramp. As he falls, she actually grabs his arm, was unable because of her position. She was just literally inches behind him to grab him to stop the fall. There's no indication in the record, Your Honor, of a lack of clarity. Ms. Forrester assessed him, and the expert has never made any determination otherwise for the plaintiff. He simply said that maybe if he did a radial pulse check, he might have been able to make a determination. But again, there was an outright refusal here to get any sort of treatment. They were on their way, and they were trying to assist him. So I would argue no, Your Honor. There's nothing in the record to demonstrate the lack of clarity.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Gregory Casino from Martin, Clearwater, and Bell. We're here for Sports and Entertainment Physicians. Your Honors, SEP, Sports and Entertainment Physicians, was not even on site and had no duty to the plaintiff, and the Supreme Court dismissed all of the plaintiff's claims against my client, and the plaintiff has not appealed that. Unfortunately, the Supreme Court went a little further than that and granted Beacon's summary judgment motion on indemnification on their indemnification claims against SEP, and found that the claims against TransCare were somehow mooted by the dismissal of plaintiff's direct claims against us.
So, counsel, you're saying that, yes, you were required to indemnify Beacon, but because TransCare took on that obligation, you had to indemnify you?
Well, Your Honor, what we're saying is...
You didn't have an initial obligation. Sorry, you didn't have an initial obligation to get insurance for Beacon?
Well, no, Your Honor. What I'm saying is those are really two separate questions here. That's the claim for the indemnification claim by Beacon, and then there's a separate claim against it for a failure to procure insurance. We argue, first off, that we believe that the claims against Beacon should be dismissed, the indemnification claims. that the plaintiff's direct claims against Beacon should be dismissed. But with regard, if the court disagrees with that, with regard to Beacon's indemnification claims against SCP, if the court finds that there's an issue of fact, we submit that if the court was to deny Beacon's summary judgment motion, it would be because it would find that there's an issue of fact as to whether the Beacon's employees were actively negligent because of the actions of the security guards who was on site and rendered assistance. And that in this situation, Beacon would not be entitled to SCP who was not on site because Beacon would be being indemnified for its own negligence.
I think sir, I'm sorry, yes. Judge Shulman, isn't the issue that you had an obligation to procure insurance so Beacon could be named an additional insured, so they were really forced to incur their own defense costs here? So that the issue is whether you should be in the loop in terms of contractual indemnification, and you dropped the ball with respect to insurance. Isn't that what that whole issue is all about, separate and apart from actual tort liability?
I don't believe it is, Your Honor. I believe that I believe there's two separate claims here. The indemnification claim.
That's what I'm speaking to.
Right.
I'm saying SEP had an obligation to procure insurance so that Beacon would be named an additional insured on that insurance policy, correct?
Yes, Your Honor.
And you didn't do that?
Well, Your Honor.
Yes or no, did you procure insurance? You didn't.
Right, yes.
So therefore, in order to defend, normally if you had insurance, they would have been able to call your SCP and say, okay, Martin Clearwater Bell, show up and represent my interests in this case. But they had to defend themselves, and therefore, part of their claim here is seeking indemnification because of defense costs. Well, notwithstanding the possibility that the case should be dismissed against Beacon.
Well, Your Honor, that's the indemnification claim would be seeking. It's a defense and an indemnification. In addition to seeking defense costs, they're also seeking indemnification to the extent saying anything that Beacon has to pay to the plaintiff, we could then get from SEP. And that's very different from they're saying the defense cost issue.
I understand that.
But so I think that's an important distinction to make. And so what we're saying is if the Beacon, as far as the money if the Beacon has to pay money to the plaintiff because the Beacon's employees were actively negligent, again, we take the position that they were not, that Beacon can then not turn around and recoup that money from us, assert an indemnification claim against us, which is what Justice Barron's order specifically allows the Beacon to do, which Beacon should not be allowed to do because under that scenario, Beacon would be actively negligent. I would just quickly talk about TransCare, which is Justice Gonzalez, is what you started talking about earlier. As part of that same order, Justice Barron also said that because the plaintiff's direct claims against SEP have been dismissed, finding that there was no duty, or there's no Espinal duty, that as a result, SEP's claims against TransCare for indemnification, those are somehow rendered moot. We would say it's our position that those claims are in no way rendered moot because as the way the order still is written, I mean, it ultimately depends what this court does with this. As the way that the order is written now, Beacon has summary judgment on its indemnification claims against SEP. In that situation, SEP's negligent, any liability that SEP incurs would be purely vicarious for TransCare, in which case TransCare would then be SEP would then be entitled to indemnification. So the claims were in no way moot. And if there's any further questions, I see my time has expired.
Thank you, Counselor.
Thank you.
Thank you very much, John Newman. On behalf of the plaintiffs, Anthony and Amy Fornabayo from Newman Law Associates. Your Honors, the bottom line with this case is if you first look at the incident report, it indicates that the plaintiff reported that he was dizzy at the time in the seat to one of the Beacon employees, the person who came down, Mr. Afumani, who's the head of security. It is absolutely a fact that both the Beacon, because of their protocols and making sure that safety was the most important thing and being close to patrons, even if they refused care, to make sure that they didn't fall, It is beyond,
How do you do that?
what's that?
How do you do that?
What does that mean?
It means simply, Your Honor, that each of the Beacon personnel who testified in this case said that no matter what the situation is, because safety is the most important thing, if somebody refuses help, that they still stay close to them. Now,
Are you denying that they were all close to him?
they were not close. No, they were not close. And you know what, Your Honor? You raised a very good point, because the Beacon had a videotape, and the videotape would have shown everything that happened in the theater. But they only turned over from the moment of the fall, from when he was just about to fall. All of the communications that they claim happened, which my clients say did not happen. Amy Fornabayo is on the record saying that.
So during the discovery phase in the Supreme Court, did you say to the Supreme Court judge, I didn't get enough videotape, give me more?
Correct.
And what
I made,
happened?
And I made a motion for spoliation, and that motion for dismissal, and that was denied. And I chose not to pursue that. I understand.
Now you can't come before us and say that that's a problem. Here's what I want to ask you. Do you deny that your client said, I am fine, I do not want any help?
Correct.
Got up and said, do not help me.
That did not happen, Your Honor.
Oh, he's saying, now you're saying your client is, what are you saying exactly?
What I'm saying simply is that at the time, all of the testimony and all of the, everything in the record, Your Honor, all of the testimony shows that Mr. Fornabayo was seen in his seat after passing out twice. He was seen by
No, how about the testimony of the trans care worker?
The trans care worker
says he was alert ×3. I asked him several times. He said he did not want assistance.
That's not accurate, Your Honor. The trans care worker specifically testified that he was sweating after passing out in his seat. That he did not say that he did not want any help.
What did he say?
She testified that she described him as being diaphoretic.
No, what did he say?
She asked him multiple times if he wanted assistance, and he said, it's embarrassing, no. Is that not what he stated?
That's what her testimony was, Your Honor.
And did he controvert that testimony at all?
The only testimony that was offered by him was that he didn't recall any conversations one way or the other.
Did anyone controvert the testimony of the trans care worker or the Beacon security officer that on multiple occasions he was asked if he wanted assistance? He said, no, it's embarrassing.
Your Honor, Amy Fornabayo, in her testimony, stated that she could not hear any and she did not see any conversations take place.
I understand that. So again, my question was, did anyone controvert the testimony of the Beacon security officer and or the trans care worker's statements that they asked the plaintiff if he wanted assistance on multiple times? He said, no, it's embarrassing.
The testimony...
I'm sorry, what was the answer to my question?
I understand.
What was the answer? It didn't call for an I understand. It calls for a yes or no.
Well, yes, Tony controverted it by saying that he didn't recall having any conversations.
That's not controverting.
And Amy testified that she, and I'll tell you specifically where.
So again, let me back up again. Let me ask you another question now, counsel. You mentioned the fact that there was some type of duty on the part of Beacon, the security officers, to be close to the plaintiff or to be close to someone in this situation. Where did you get that from? Where is that stated in the record?
From both of the witnesses who testified that anytime somebody needs assistance, that they go to the assistance of that person, that it is their protocols which they follow day in and day out at every single event, and even under the foreseeable occurrence where a patron says, no, I don't need any help, they will specifically stay next to that patron to make sure that that patron doesn't have any incident where they fall and they get hurt.
So here's the problem, counsel. So we know that an adult can refuse medical assistance. We know that an adult can refuse help, right? And an adult can refuse even essential treatment. And an adult can decide that they don't want essential treatment and they want to die, right? We know this. Okay, so here you have someone who says, I don't want any help, according to the testimony of the Beacon security person and the EMT. The EMT also has findings. He was a little dazed, but he sat in his seat for a while. He was conscious. He was alert and oriented ×3, and so on and so forth. When you say that they were required, speaking of the EMT worker and the security person, that they were required to remain close to him, are you trying to set up a rule as far as how close they were supposed to be? Because if they had put their hands upon him, wouldn't that conduct be actionable, perhaps?
Absolutely not, Your Honor. This is somebody who presents upon the moment that that they were called, they all descended on the seats, and my client they already knew that that Mr. Fornabayo had passed out in the seat twice. He was sweating profusely. He was dizzy. These become questions of fact concerning what the options were at the time and whether reasonable care was effectuated after both TransCare, after looking at Mr. Fornabayo, and also the different personnel who appeared from the Beacon, whether or not they properly, reasonably took care of him after putting themselves out there and following their own protocols. Which
Did he ask to go outside the theater, the enclosed, the audience space?
Well,
or did the EMT ask him to step outside? Or does that not make a difference?
The EMT testified that she could not do whatever she needed to do.
Check his vital signs.
Evaluate him and escorted him, and that is specifically in the incident report, that they were escorting him to the front where they wouldn't be in the theater themselves. And they had options as to how they were going to transport him. This patient, to their knowledge, had lost consciousness twice, was sweating, and was dizzy.
And therefore, they should have what?
And therefore, because they had on other occasions, according to the EMT, either wheeled him out or put him on some sort of flatboard or a stair chair, there were other options that they had at that time, but yet they chose to transport him from point A to point B in a way that was reckless.
Thank you, Counselor. Thank you so much. Thank you all.
Thank you very much.